Unacampo deterrence is the prime object of the crime law, according to some, is the protections of the public by the reductions of crime and the maintenance of law and order. The prominent judicial views that this object is attained by deterrences. Primary and secondary deterrences. Deterrences of two types, primary deterrences and secondary deterrences. Also referred to it as individual deterrences and general deterrences. Primary deterrence is for the offender himself, while secondary deterrence is intended to deter others from committing the same crime. The idea common to the deterrence theories of punishment is that experiences. Threat example of punishment discourage crime. When courts speak of protecting society through the deterrences, they are generally speaking of secondary deterrences. That is the deterrences of others and not the deterrence of the offender. Long-term and short-term deterrences. There's another aspect of theory of highlighted by Cross under the title of long-term deterrences. He maintained that most views pertain theories of short-term deterrences as compared to these short-term theories. The long-term views maintain that deterrence helps society to build up, maintain people standard. This over the period of time people may not obtain from the time due to fear but to their inner feeling about his weakness. Reformation in modern times, the substantial part of the legislation is directed towards the rehabilitation of offenders. This is one of the main purposes of punishment. A large number of writers also maintain the reformation should be the main. Deterrences and reformations. A large number of writers also maintain the reformation should be the main. If not only the object of sentencing, but there are those who oppose this view. Mobat had the following to say about some sentiments of reform. It is often thought that the reform theory is modern and human compared with the retributive theory, which is primitive and barbaric. But the essential point about the retributive punishment is that it treats the criminal as a man. To be punished for reform season is to be treated like a dog. Demands to be held responsible for this action, and he rejects as an intolerable insult the well-meaning exclusion of the scientific, whether present at social or psychological ground. Retributive punishment, close amount reform punishment opens. Preventive. According to prevention theory, the object of punishment is to incapacitate the offender from committing the further crimes. The protections of society from the offenders' murderings, even for the comparatively short time, is frequent. Judicial justifications of sentences. In reality, the theory of prevention cannot be considered a separate theory because it uses all the different approaches into deterrences to prevent the commission of crime. This element of prevent theory is in the minds of those who maintain that no single theory can yield perfect result. Punishment is broad and general program in which we should consider each important group of crimes separately. Yet too much generalization becomes ineffective. Substitutory. The restitutionary justification focuses on the effect of the offender's wrongful act on the victim. Other theories of punishment conceptualize the wrongful act as an offense against the society, the restitution. The theory sees the wrongdoer as an offense against the victim. On this way, the principal purpose of punishment must be to make a victim whole to the extent that this can be done. The point is that not the offender deserves to suffer, it is rather than offender party desires compensation. According criminal convict of the wrongdoing should be sentenced to compensate the victim is proportion to the victim's loss. The problem with the restitutional theory is that it fails to distinguish between compensation and punishment. And compensatory object focus on the victim, while punitive object focus on the offender. Today, this is being called restitutive justice, and there's a big debate about it. Civil justice, the goal of the civil justice system is the adjudications of rights. The excellent alliances provide the sermon book on the jurisprudence. This is the summarize the value. Right enforced in civil proceeding either primary rights or essential rights. Primary rights arise through the norms, while essential rights arise through the violations of primary rights. My right not to be assaulted a primary right, but my right to obtain the pecuniary compensation after assault is the essential right. My right to the fulfillment of contract between me is a primary right, while the right to damage for its breach is an essential right. The administration of civil justice considers the following to two parts on the basis of two types of rights. Sometimes it is impossible for the law to enforce primary right, while at other it may be possible not the proper things to do. If A destroys B is a property by negligence, A has the right to that property the extent and no longer enforce the law provides substitution of property in the form of monetary value of property. We may conclude from this their essential rights usually consist of claim to money. Hada enforcement of private is called specific enforcement by Salman, while that of essential right is called essential enforcement. Example of specific enforcement, the enforcement rights are as follows. Proceeding through which the defendant is compelled to pay the debt, proceeding for the restitution of property wrongfully detained, proceeding to restrain someone from committing trespass public nuisance, proceeding to make the defendant repay money obtained by fraud. In all these cases, law is trying to insist on the establishment of the original state of things before the violations of the right, not of things. There is equivalent or substitute. The American realists maintain that leaving aside equilibrium like a space performance objection is only essential rights which are reality and with which the courts are concerned. There is no primary right that another shall perform as a contract with me. There is simply essential right that he shall pay me damages. If he breaks this, in other words, the primary right is systemically through the essential right. Salman next day to conclude from the hour there are no primary rights to be confused what right is and to mistake right for the method enforced. We are assumed that the essential right is merely the method in any case. This has to do with the meaning of right and duty. Second, the functions of courts in civil justice. According to some, there are sections that don't fall within the meaning of administrative justice in the strict sense, but in the wider sense of the term they do. The second functions of courts fall into four: action against it, action against the state, the judge is own God, claims and you are made against. This was the action tried as it was claim between the justice. The damages may be awarded the state cannot be on the state. Nevertheless, the principles are part of the declarations of right. A litigant may claim the assistance of court of law not because rights have been violated. There are certain. He requires an authoritative declaration that a right. Such a declaration may then administration. This pattern the management is difficult property like the administrative trust. Title rights, judicial decree enforce the existing right like in jurisdiction against the alleged or by the rule.